Imagine getting a phone call from your child's school, and the principal is stammering, struggling to find words, describing a unique situation where your 6-year-old was poked with an unknown object on the playground. You take the man at his word. Your child is fine, he says. But then, an hour and 15 minutes later, the story completely falls apart, and you find out the truth is far more terrifying than anything you could have imagined. That is exactly what happened to one Michigan mother, and what unfolded in the hours and days after is a story about a school's catastrophic failure to protect the child, a cover-up that may have endangered a 6-year-old's health, and the very real legal options available when institutions let our kids down in the worst possible way. Let's get into it. To understand why this situation is so serious, you need to understand a few things about who was involved and what was at stake from the very first moment this incident occurred. A 6-year-old boy was sitting in his school cafeteria during lunch on a Wednesday, talking with his friends, doing exactly what any normal kindergartner does. Out of nowhere, another 6-year-old child, someone with no prior history with this boy, according to both the child himself and the school principal, walked up behind him and jabbed him in the back with a used diabetic lancet. For anyone who doesn't know, a diabetic lancet is a small, sharp needle device used to prick the skin and draw blood for blood sugar testing. The key word here is used. This was not a sterile needle. This was a needle that had already been used on someone else, potentially carrying bloodborne pathogens like HIV, hepatitis B, or hepatitis C. The child who committed this act reportedly told adults he found the lancet on the playground. After stabbing the boy, he showed no remorse and immediately tried to get rid of the evidence, tossing the lancet away. Fortunately, another student witnessed this, picked up the lancet, and handed it to a staff member who had come over to help the injured boy, who was visibly in distress. This is the situation the school principal had on his hands by roughly noon on a Wednesday. A used needle, a 6-year-old with a puncture wound in his back, a potential bloodborne disease exposure. And here's where the story takes a deeply troubling turn. At 1:01 in the afternoon, nearly an hour after this incident occurred, the mother received a phone call. Her husband was present and heard everything. The principal was, by her account, stammering and clearly at a loss for words. He described a unique situation on the playground involving a student poking, his word, multiple students in the back with an unknown object. He had been in possession of the lancet for close to an hour at that point. He knew what it was. And yet, he told this mother her son was fine and that they were still trying to figure out what the object was. She asked directly if her son's skin had been broken. He told her the child was fine. She took him at his word. Then, at 2:15 in the afternoon, the principal called back, and this time he admitted it was a needle. He admitted it happened in the cafeteria, not the playground. And suddenly the story shifted again. Now her son was apparently the only victim, and the principal claimed he had simply not had his facts straight and jumped the gun in his earlier description. But here is what makes this claim deeply suspicious. The injured boy later told his mother that multiple children who had not witnessed his injury were pulled out of class for short periods of time that afternoon. Why would unrelated children be removed from class if only one child had been involved? The mother's conclusion, and frankly, it's a reasonable one, is that the principal was attempting to manage the situation quietly, minimize the severity, and control how the parents would react. When the needle could no longer be concealed as an unknown object, the strategy shifted. Now here is where the school's failure compounds into something that is legally significant. When this mother arrived to pick up her son, hours after the incident, she discovered that nobody at the school had provided even the most basic first aid. No soap and water, no antiseptic, no bandage. A 6-year-old had been punctured by a used needle, was visibly in distress, and the school did nothing to clean or treat the wound in the hours that followed. She also discovered, when she returned to the school to retrieve the lancet so she could show it to the pediatrician, that the child who had stabbed her son had spent the entire rest of the school day on campus and had been sent back to the same classroom as his victim. Her son actually saw this child in the principal's office, when they came to collect the lancet. She immediately sought medical care. Because the principal had delayed telling her the truth about what happened for over an hour, and because that delay meant hours had passed before proper medical evaluation could begin, her son had to have blood drawn the following morning to test for blood-borne diseases. And then they waiting to find out if your 6-year-old has been exposed to HIV or hepatitis because a school failed him. There are almost no words for what that experience must be like as a parent. The next day, they were informed the other child had been suspended, though the school declined to share the length of the suspension. So what are the legal options here? Because this family has more than one avenue to pursue, and understanding each of them matters. First, let's talk about negligence and premises liability. Schools have what is called a duty of care toward the students in their custody. When a child is at school, the school stands in a position of responsibility for that child's safety and well-being. The failure to discover and properly dispose of a used medical needle on school grounds before a student could find it and use it as a weapon is a significant breach of that duty. If the lancet was on the playground and a child found it, that raises serious questions about the school's maintenance and safety inspection procedures. Second, there is the failure to render appropriate medical care. Once the incident occurred, the school had a responsibility to ensure the child received first aid and that the parents were notified immediately with accurate information. Waiting nearly an hour and a half to call the parent, then providing deliberately vague and misleading information about what happened, then failing to clean or treat the wound in any way. All of this could constitute a separate basis for liability. Third, and this is critically important, the deliberate or reckless misrepresentation of what happened may have caused direct, measurable harm. Because the mother was not told the truth about the needle until 2:15 in the afternoon, there was an additional delay in her son receiving appropriate medical evaluation. In cases involving potential blood-borne disease exposure, time matters. Protocols exist specifically because early intervention can affect outcomes. If the school's deception caused a delay in care, that delay is legally significant. Fourth, this family should be documenting everything right now. Every phone call, dates, times, what was said, who said it, every medical visit, every test, every bill, every communication from the school, whether verbal or written. They should be requesting, in writing, the school's incident report, their safety inspection logs for the playground, their medical emergency response protocols, and any communications between staff members on the day of the incident. Under Michigan's Freedom of Information Act, public schools are required to respond to records requests. Fifth, they should consult with a personal injury attorney who has experience with premises liability and educational institution cases. Many attorneys in this space offer free initial consultations. Given the facts here, the physical injury, the potential long-term medical implications, the school's failure to provide first aid, the misleading initial communication, the failure to separate the offending child from the victim, there is a meaningful case to be evaluated. One more thing worth knowing, Michigan has specific notice requirements for filing lawsuits against governmental entities, including public schools. In many cases, you must file a formal notice of your claim within a specific time window, often as short as 60 days, before you can pursue a lawsuit. Missing this deadline can forfeit your rights entirely. This is not something to delay on. Speaking to an attorney sooner rather than later is essential. What this story ultimately illustrates is something that every parent needs to hear. Schools are institutions, and institutions protect themselves. When something goes wrong on school grounds, your child's safety and your right to accurate information can sometimes take a back seat to liability management and damage control. The principal in this situation had a used needle in his possession for nearly an hour and described it to a mother as an unknown object on the playground. That is not an accident, that is a choice. And choices like that have consequences, both for the child who was harmed and potentially for the institution that failed him. Know your rights. Demand complete information. Do not accept vague answers when your child's health is on the line. Get medical care first, then document everything. Then talk to a lawyer. If something like this has happened to your child, a school injury, a failure to notify, inadequate supervision, or medical neglect on school grounds, please do not wait to get information. Start by writing down everything you remember while it is still fresh. Request records. Consult a local attorney who handles cases against public institutions. You have rights, and so does your child. If you found this video helpful, please subscribe. We cover real legal situations every week, so you know exactly what your options are before you ever need them. Share this with any parent who needs to hear it, because the more we know, the better we can protect our kids.